So you're thinking about starting a business with someone else. That's awesome. But before you jump in, we need to talk. We're going to dive into the world of partnerships, a business structure that can be incredibly flexible, really powerful, and, well, you're about to see surprisingly dangerous if you're not careful. All right, let me ask you something. Picture this. You and a friend are at a coffee shop. You're hyped up, you're sketching this amazing business idea on the back of a napkin. You decide right then and there, let's do this. We'll split the work, we'll share the profits, we start Monday. So my question is, did you just legally form a business? The answer, and this might shock you, is a huge yes. You very well could have just created a general partnership. And here's the kicker. It can happen completely by accident. No paperwork filed, no lawyers called. And that, my friends, is where things start to get really, really interesting. So how on earth does that happen? To get our heads around it, we first have to understand what a partnership actually is. And honestly, there's no better way to see how this works in the real world than with a story about a family and their little deli. Let's talk about the Murrays. You've got three siblings who ran a delicatessen together for years. They never signed a single contract. But, they acted like partners. They ran the place as a team, they split all the money three ways, and they told everyone they were partners. So when a fight eventually broke out, a court had to step in and decide, was this a real, legal business? And the court looked at their actions, the fact that they shared profits and control, and said, you bet it was. An oral partnership existed, plain and simple. Okay, so what's the official definition? Well, at its heart, a partnership is just two or more people agreeing to be co-owners of a business to make a profit. Simple enough, right? The law even sees the partnership as its own separate thing. It can own property, it can get sued, but, and this is the catch you have to remember, the partners themselves are still personally on the hook for every single one of the business's debts. And that brings us to the two giant differences between a partnership and, say, a corporation. First up, liability. In a partnership, if the business owes a ton of money, creditors can come after your personal stuff, your house, your car, you name it. In a corporation, the shareholders are mostly protected. That's a huge deal. Second is taxes. Partnerships have what's called flow-through taxation. The business itself doesn't pay taxes. The profits just flow through to the partners and you pay the tax once. Corporations, on the other hand, can get hit with double taxation, where the company pays taxes and then the shareholders get taxed again on their dividends. Okay, so if you can just stumble into a partnership with these huge legal consequences, how do you actually protect yourself? How do you stay in control? Well, it all boils down to one absolutely critical document. Your partnership agreement is, and I mean this literally, the supreme law of your business. It's the contract where you and your partners get to write your own rule book. If you don't have one, or if your agreement is silent on an issue, then the state's default partnership laws just take over automatically. And trust me, you probably won't like those default rules. Let me show you what I mean. Let's talk profit splitting. Without an agreement, the state's default rule is super simple. Profits are split equally, 50-50. It doesn't matter if you put in 90% of the money and do 90% of the work. The law just assumes you're equal. You can imagine the kind of fights that causes. But with a written agreement, you can customize it however you want. If partner A puts in 70% of the cash, you can agree to a 70-30 split. Your agreement overrides that default rule. It becomes your law. So what needs to go into this thing? Just think of it in four big buckets. First, the money. Who's putting in what capital? How are we splitting profits? And, just as important, losses. Next, the power. Who's in charge of what? How do we vote on big decisions? Then, the people. What's the process for bringing on a new partner or for letting one go? And finally, the end. What happens if we decide to close up shop? A great agreement answers all of these questions before they become problems.
All right, you've got your agreement, which is your blueprint. So now, how do you actually make decisions day to day once the business is up and running? This is where things can get messy if you haven't laid out the rules of the road.
Remember those default rules we keep talking about? Well, here's another big one. Unless your agreement says something different, every single partner gets an equal say. One partner, one vote. And for what the law calls ordinary business decisions, a simple majority is all it takes. But what in the world counts as ordinary? I mean, deciding to switch coffee suppliers? Sure, that's ordinary. But what if your two partners want to take out a massive $100,000 loan and you think it's a disaster waiting to happen? Can they just outvote you? Probably not. Big moves like taking on huge debt or selling off a core part of the business, those are usually considered extraordinary, and they require a unanimous vote. But that line between ordinary and extraordinary can get blurry, which is exactly why your agreement needs to define it. So beyond all the votes and the money, there is a much, much deeper level to being in a partnership. I want you to start thinking of it like a business marriage. Because with that marriage comes a legally binding vow of loyalty that is incredibly powerful. And the most famous story about this duty comes from a landmark case from way back in 1928, Meinhard versus Salmon. It was about two guys in a joint venture to manage a hotel in New York City. As their lease was about to run out, this incredible new development opportunity came along, an opportunity that only existed because of the business they had already built together. So what happened? Well, one partner, Salmon, was offered this fantastic new deal, and he kept it completely secret from his partner, Meinhard. The judge in the case, the legendary Benjamin Cardozo, wrote one of the most famous lines in business law. He said that partners owe each other more than just basic honesty. They owe the punctilio of an honor the most sensitive. It basically means the absolute highest standard of loyalty you can possibly imagine. So let's just break down exactly where Salmon went wrong. A huge, valuable opportunity popped up, and it was directly tied to their partnership. But instead of bringing that opportunity to the partnership, Salmon secretly grabbed it for himself, cutting his partner Meinhard out completely. The court said this was a textbook breach of the duty of loyalty. You just can't take an opportunity that belongs to the partnership and keep it for yourself, period. We've talked about control, we've talked about trust, but let's wrap this up by focusing on the single biggest financial risk you take on the moment you become a general partner. Okay, this is the big one. It's a concept called joint and several liability. It sounds technical, but what it means is actually terrifyingly simple. It means that if your partnership owes money, a creditor can sue any one partner for the entire debt, not just their share, 100% of it. Let's look at what that actually means. Say your business racks up $100,000 debt, but there's only $20,000 in the business bank account. The creditor can take that $20,000 and then go after partner A's personal savings for the other $80,000, or they could go after partner B's house, or some from both. The point is, they can chase any of you until the full amount is paid. Your personal wealth is completely on the line. So let's bring it all home. What are the key things you need to walk away with? First, flexibility. Partnerships let you write your own rules, but only if you have a great agreement. Second, risk. This is a big one. Your personal assets are not safe from business debts. Third, trust. The duty of loyalty between partners is the highest it gets. And fourth, taxes. That flow-through tax treatment is a major upside, letting you avoid getting taxed twice. Look, if you remember just one thing from all this, let it be this. A partnership is a business marriage. And just like a real marriage, you hope for the best, but you have to plan for the worst. That partnership agreement is your business prenup. It protects everybody. It gets you on the same page. So please, whatever you do, do not start a business with someone without one. And that really just leaves us with one final question for you to think about. Knowing the level of trust it's required, knowing the financial risks involved, who in your life would you actually be willing to enter that business marriage with? It's a serious question, and one every entrepreneur needs to answer.